serving as a lawyer's lawyer, someone being an outside ethics counsel to lawyers within the profession, what do they exactly do, right? What do they offer to clients? Well, largely in this advisory space, we look at whether there was an ethical duty to do something when a set of facts are presented to the lawyer. Should you have done something here, or should you not have done something here? So we point to a set of rules within our rules to see if there was some duty that the lawyer had. And then the question was that duty violated in any way? And if it was violated, could it be remedied or cured in some form? And now, after the fact, are there any preventive or remedial steps that can be taken through things like training classes, establishing policies and procedures so that this doesn't happen again, or other forms of controls? In everyday practice, it may be surprising to some of you, but all kinds of issues arise. Some of them could be small things, but could become bigger if left unattended to, or they could just be big things and they need to be resolved. And a large majority of them involve situations where the client could potentially be harmed. And that's a problem, because the rules are really set up to regulate lawyers so that they avoid misconduct and prevent harm to clients and to the public. Here are some examples that can come up in any lawyer's practice, practicing in India, in the US, or anywhere in the world, whether as a private practitioner or in-house, and regardless of the type of practice, right? Accidental disclosure of client confidential information. It could happen through the autocorrect function in an email. The wrong name gets pulled up and sensitive information is revealed in an email. You can't unring the bell because it's sent and sometimes it cannot be retrieved, those kinds of emails. Mistakes come up in preparing documentation. Missing a zero can be a monumental mistake in, say, a loan document, right? Missing deadlines. Communication with a represented party, that's prohibited under our rules. Dipping into the escrow funds of a client, that's very, very problematic. So these are examples I give you because the ethics practice is really geared towards providing guidance and solving problems of these types when they arise. Are held to such a high standard of conduct under our rules. The rules don't provide a particular order of importance of what rules should be complied with and how, in terms of the most important to the least important. They're all important. But I will pluck out a few that I think are just critical for every lawyer to kind of have in the front of their minds as they practice law. Confidentiality, that's really the hallmark of a client-lawyer relationship. And it's interesting because now that we're in a work from home environment and using and our remote, we're using technology more than ever. Confidentiality is something that we all need to be much more conscious of and aware of. But pre-COVID and sort of the pre-work from home environment, we saw that lawyers using modern technology had to be careful of these issues also to avoid unauthorized access to electronic documents, to avoid inadvertent disclosure. Having electronic documents today puts us on a very different playing field from when we had printed out documents in a locked steel cabinet. So I think that with technology and now with the way we all practice from home, we have to be extra careful with client confidential documents, even documents that are printed and left lying around on the dining table. They're confidential. So we want to protect our computers, just as much as we want to protect our kitchen tables. And of course, with video conferencing tools today and some of the functionalities, being aware of the security features has become even more important. Um, Aside from confidentiality, professional independence of lawyers is another key duty. Um, Being free of pressures from non-lawyers and from the control and direction of non-lawyers is really important. In New York, our rules prohibit non-lawyer ownership, investment, control, and direction from lawyers and from law firm practices. Um, and much of that is to do with keeping the lawyer's judgment, which is perhaps the most important thing about what we do, free from outside interference and outside impairment. Beyond that, I would say that avoiding conflicts of interest is one of the most important duties that we owe our clients, because after all, they come to us in a situation of trust. We owe a duty of loyalty. And when there's a conflict of interest, especially with a current client, where a lawyer is representing a client in one matter and then in another unrelated matter is adverse to that client, even in a transactional context, it's an issue of betrayal to the client. One client may think that the lawyer is being more deferential to the other client. So it raises all kinds of problems, and there are a number of rules on conflicts. And that's another, I think, essential rule to keep in mind, including when lawyers are moving from one firm to another. There are some situations and troubling situations, I would say, that I've been involved in on behalf of clients in their practice. I'll share a few of them. One involves investigations where lawyers within organizations and the organizations themselves have been subject to some scrutiny to see what those organizations were providing to others in terms of legal services, and what the roles and responsibilities of the lawyers within those organizations, in-house lawyers, were doing in terms of their services that were rendered to others, to other corporate entities. So the reason that this is an issue is because of unauthorized practice of law. Lawyers can practice law, those who are properly licensed. What we had to look at was in the few instances that I've been involved in these investigations, is the corporate structure and the organizational relationships of the entity with other entities for whom lawyers may have been furnished for legal services. To the extent that the entities, which could have been separate legal entities, were affiliates or subsidiaries, wholly owned or partially owned, of those organizations, the lawyers can, of course, provide legal services. They're registered to do so within their states. They're licensed. They're advising the organization's own entities, owned entities. But the issues also surrounded these other entities with which the organization had relationships. And we had to look at whether those were entities that the organization owned, or whether those were more contractual relationships where there could have been a risk that services were being provided almost as though that organization was a law firm furnishing legal services to the outside world. And there are very strict laws with some very clearly worded exceptions, but there are laws and there are ethics rules on these issues. And these are very significant issues for non-legal entities. And compliance with these laws and rules, again, becomes very important, both for the non-legal entities and for lawyers who are practicing in-house. So that was a pretty significant issue, and the investigation of that involved reviewing the structures, providing guidance, setting up some controls and best practices so that the organization could sort of retrain people internally and move forward with their own objectives and goals without finding themselves in any kind of ethical or regulatory or legal hot water to do with lawyers moving firms. And this is a common practice. Maybe it happens more nowadays than it did before. And it doesn't matter where or in the world the lawyer practices, but the situations I've been involved in turned out to be somewhat thorny because, the lawyers want to make a move. They have the right to be autonomous. But in the situations I was involved in, there was the old firm involved, the new firm involved, the lawyer in the middle, but most importantly, the client who, was really impaired from all the things that happened. The lawyers, in some cases, it's a group of lawyers, and I'm giving you, this is sort of the context here, left the firm and emailed a number of documents that they forwarded to their own personal account from the firm's computer system. They were all client documents. And then from the personal email, forwarded them on to the new law firm. And they made a transition very quickly, but it was very acrimonious. No notice was given to the firm, and the clients were called, but about the move. But from a professional responsibility standpoint, the clients, the firm needs to be notified first of a move. The firm and the lawyers are supposed to work together to make sure that the clients are given the opportunity to decide, because they have the right to choose counsel, the right to decide whether they want to stay with the old firm, go to the new firm, or go to some other firm. And here, none of those notices to the client were provided. Their consent to transfer files was not taken. So, the boxes of files were going to the new firm, and emails were forwarded from the firm's computer to the personal computer to the new firm. And the clients were left unprotected in all of this. And it was not it was just a, terrible situation. The first law firm shut the lawyer down from his office. The lawyers involved were locked out of their computer system. So it was very messy. And this situation and similar ones that I've been in like this, again, you come in after the fact, and you're trying to resolve a very delicate and kind of a hostile and acrimonious situation where the client is kind of the one who was not protected properly. All files belong to the client, not to the lawyers. And the decision to move or to stay is really with the client, not with the lawyers. So there was a lot of fighting that went on, which could have clearly been avoided if they went out and sought advice on how a smooth transition should be, and what some of the professional obligations and duties are for lawyers, as well as the law firms they're leaving and the new firms that they're going to make the process smooth and professional.